From supplementary list, item number 1 for pronouncement of judgment.
You condone the delay.
At least I have partly succeeded.
Your application has succeeded. We refer to the two judgments principal judgments that you cited.
Yes, sir.
Sharma and Fernandez. You referred to not being a constitutional right. Doesn't matter.
Yes, sir.
As long as it's a right. And ultimately, we've said that just read out 2 or 3 pages.
Yes, sir.
That we said that the issue which arises here were not there in either Sharma or in Fernandez. Though Ajit Sharma expressed some reservation as to the invocation of jurisdiction by a teacher to assail a condition in the grant, more recent judicial pronouncements of the highest court have widened the scope of Article 226. Further, in the present case, it cannot be said that the petitioners were not affected by the impugned amendment or the lack of authority of the state or its arbitrariness or unreasonableness in imposing conditions that affect teachers would still not entitle the teachers to invoke the jurisdiction. At any rate, in view of the last 5 words of Article 226, as much as it says, and for any other purpose, it cannot be lost sight of that as long as there is a public element to the list valid under such provision or a government action which is assailed, the writ court must be seen to have the authority to entertain the complaint. The judgments in Sharma and Fernandez are distinguishable as the impugned government actions were assessed on terms of the granting aid codes. In neither case did the court have to consider the disqualification of such magnitude as introduced by the notification. It is needless to enter into a debate whether the right to vote and whether consequently or otherwise the right to contest elections to any legislative or public body is an inherent right or a constitutional right or a mere legal right as long as it is recognized as a right. However, it may only be said that once the preamble to the Constitution declares the state to be both democratic and a republic, there is a promise held out therein that subject to what may be prescribed by any procedure established by law, any citizen of this country would be entitled to both vote and contest elections to legislative and public bodies. Though it may be banal in going into the etymology of the word democracy and its Greek origin, democracy in the modern day is popularly understood in the words of Abraham Lincoln from his Gettysburg Address of 1863, where he referred to government of the people, by the people, and for the people. Both the principles of the people and by the people encompass the wider concept of the right to participate in the formation of government by both having a right to vote and a right to contest in the larger sense of the word that the concept of democracy conveys. Doubtless, such rights may be curtailed, but that must be under due authority of law. Again, as this great nation was also conceived in liberty and dedicated to the proposition that all men and women are created equal, the right of a state government to interdict a citizen's right to contest the election to any legislative or public body or office in a political party by making a vanishing distinction between a position and a person must be guarded against. Thus, for reasons entirely different than as indicated in the impugned judgment, the writ petition is allowed and the impugned notification of 23rd March is set aside, restoring the position to as it stood immediately prior thereto. The amendment introduced by the notification is found to be in excess of the authority available to the state government and otherwise onerous, unconscionable and unreasonable. The impact of the amendment on the individual teachers is so overwhelming to the extent it curtails a fundamental legal right and the only choice available to the teacher is to effectively give up his livelihood, that the distinction between the post and the person is illusory. The appeal is disposed of, no cause.
Highly obliged.
Yes. Sign it later, over 20 pages to sign.
From the minutes, item number 1.
Is the thing? Lordship, can I just formulate the,
Yes, yes.
after this heavyweight judgment, I thought shifting to criminal, after this heavyweight judgment on constitution and preamble,
Yes.
Lordship, after a series of hearing that we had in this Burnett matter, there are a few things that I'd like to formulate, Your Lordship. Admitted position. It will be easy for us to navigate the way through. First, Your Lordship, it's an admitted position that both Burnett and Bonnie was last seen with the deceased. And we are separating the confession part from the admission part. So that last seen theory, the starting point is on the basis of an admission.
We don't, subject to hearing even greater detail, we don't have to go how they go up the steps.
Absolutely, Lordship.
How they go up the steps, how they arrive at the base of the hill.
Lordship, absolutely.
Our story starts from how they are at the graveyard.
Absolutely.
Because up to there is, and we believe that there is no section 34 over here.
Absolutely.
There is no section 34.
But Lordship, there is a provision under 261. There are provisions where under 261, if only in a case of a prejudice, then maybe the re-examination is required. But the available evidence are there. Then it could be a case of the power is there.
At the appellate stage, we will not exercise. Even though it is there, but at the appellate stage, we will not exercise.
The power is there, sure, but it's subject to a court's discretion, but the power lies there, Lordship, because the 34 is the common intention. So, Lordship, just allow me to formulate. So, the starting point is that they were in the grave. Last scene theory, Lordship, let me just make the concept clear. Last scene is this: there has the accused should be seen last together with the deceased, and the time gap should be such small that there could not be any other circumstances or anybody else who could have intervened. Now, in this case, Lordship, last scene is admitted. What happened previous to that, Lordship, I will not waste the court's time because we are all aware of it. What is the law governing that? So, two things very important that emerges is that they were seen together, and second, the time gap of death. This also statement comes up from the accused.
Time gap of?
Time gap when the death occurred. Last scene, the starting point is very clear, admitted position. Death also is very clear. The deceased died in the lab. Now the only issue so far of last scene theory, my first formulation would be on the last scene theory. The first formulation would be last scene, and now the only gap is whether this has come out from somebody else, this evidence, or it has come out from the accused. And if it's an accused, then it's an admitted fact under the Evidence Act. Now, seen together and death, the gap is very minimal. So we overcome that hurdle, Your Lordship. We don't have to, the gap is not so much that we have to look for other evidence. If something could have happened, some third person, fourth person could have come. Now, the issue remains now the cause of death. That is the subject matter. The cause of death, Lordship, will be solely governed by 106. Last scene theory starts from when they are together. And there is an exception to other 102, 101, 104 because 106 of the Evidence Act clearly says the burden to discharge the burden lies with the accused. Now, Your Lordship, discharging the burden is something which I'd like to elaborate. The statement of the accused is that Biplab Das died on his lap. That is his statement.
Bonnie.
Bonnie makes a statement.
Bonnie is lap.
Bonnie's lab.
Bernard is the one who went out for a cigarette.
Went out. Now, Lordship, whether he has discharged the burden, there are two important legal issues, Lordship. First is this, whether he has discharged the burden. Second would be if the discharging of the burden is false. Discharging the burden is one thing, Lordship. Second thing is whether the discharging of the burden is false or whether it's true or false.
No. If he discharges the burden, it must be true. Otherwise, he fails to discharge.
Absolutely, Lordship. But I'm just trying to make Lordship is correct. I'm just trying to make a distinction because so far he's saying that he died in the Bonnie is saying died in the lab. Apparently, it looks like he has discharged the burden. If you strictly go by the principle of 106, he has discharged the burden to say how did the death occur? Oh, sorry, where did the death happen? Between being together and where did that happen, he has discharged the burden.
No. It's slightly different.
Lordship, yes.
Take the most common example. Take the most common example on 106. Two people enter a room. One comes out and says that the other is dead.
That is correct.
So the burden is on the life to say how the one who has died.
Absolutely. That's why I'm coming to that.
Because the onus is not discharged by saying died when, where, how.
Initially, this is slightly peculiar, Lordship, because this is a peculiar, very, very peculiar and unique case on its own. Initially, the principle so far 106 is concerned, it seems like, yes, he has explained it on his lab. But Lordship, that is not correct. That is exactly.
Explanation must stand the test of evidence.
Absolutely correct, Lordship.
How did he die? He died he was trying to switch on the fan and he got electrocuted.
Lordship.
That's an explanation, very good. But the postmortem shows no, he was strangulated.
So, Lordship, I'm coming to the second part. The first limb would be whether he is discharged or not. Lordship is correct. I don't want to go hair splitting on the principle, Lordship. But the substance is whether did he die in his lab? Number one, what was the cause of the death? Bonnie's statement is only simply that after vomiting he died in his lab. Whereas medical evidence, Lordship, directly contradicts it was a case of strangulation. Now, first part is this, Lordship, strangulation, there's a contradiction, or rather not contradiction, it's a case of a false statement. That means he has not discharged the burden of the cause of death. Number one, Lordship. Number two, Lordship, incriminating circumstances, the principle of incriminating circumstances against Bonnie, which will add more circumstantial evidence so far last seen theory is concerned, only in the issue of cause of death. First he has given a false statement because that directly contradicts with the postmortem. Second, Lordship, there are two parts to it. In the statement that was recorded by the magistrate, he says this statement was never recorded. Lordship, at length, Lordship has gone on the previous date. The question was never put to the magistrate, what he raised in 313. And it's a settled position of law, Lordship, if you have not put the question. And Lordship, the other query that came from your Lordship was there was no personal interest for magistrate to have a false recording. He is denying, Lordship, he is denying the very recording of the 164, which on the face of it seems like it's an incorrect statement. So if it's an incorrect statement, your Lordship, that's an additional incriminating circumstances which adds more evidence to the medical postmortem report.
Guilty mind.
Guilty mind. That is the second stage, your Lordship. That adds one more point in the prosecution case. And the link is more completed. Third, your Lordship, he has never come to the witness box as a different witness to explain. He had an opportunity. And that could still be a situation where we could contradict between the magistrate and him. He never appealed the opportunity to explain the cause of death, which he had as an accused. Number 4, Your Lordship, number 4.
Yes, carry on.
Right. Number 4, Lordship, in 313 statement.
Yes.
He has made a false statement. In 313, Your Lordship, there are two false statements that he has made. One is regarding the recording, which is an additional circumstantial evidence that add more evidence to the prosecution. Second, he's also denied.
What is the false statement in 313?
The magistrate had no, he never made a statement to the magistrate. And never had a chance. Rather, he never had a chance to explain to the magistrate. No, nothing was recorded. That particular question was never put in cross-examination. Lordship had dealt at length the other day. So in his admitted position, Lordship, I will not try to take the court in that, except if the court wants it. And another important aspect, Lordship, in 313 is this: he's also denied that he made a statement, that accused died in his lap. So one more additional piece of evidence, incriminating evidence against him, only on the factum of whether the Biplab Das died in his lap or not. If there are three evidence, these are three very crucial evidence, Your Lordship, that proves, answering the query that fell from your court, Your Lordship, that he has not discharged the burden of 106. The time gap is so small and he is not discharged. Now, Lordship, if he has not discharged the burden, the murder weapon, of course, if the court needs, we can substantiate that, but this becomes secondary. So 106 is an exception where this is a prime role, Your Lordship. So there are three incriminating circumstances that clearly prove that the cause of death.
Now, did the two accused or either one of them lead to the dead body?
Lordship, yes.
So you'll have to show the evidence in this.
Lordship, yes, we'll come to it.
The evidence as to the rope is terrible. You don't have.
Lordship, that also I can satisfy Your Lordship. There's a law on that very clearly. Lordship will recollect 25 and 26. P18 contradicted. But then IU himself has done it, Your Lordship. And so there's a very interesting area of hostile witnesses. If the IU himself has done it and one of the witnesses becomes shaky or turns this thing, it does not affect. So for rope,
show us now.
allow me to complete the last scene theory.
Yes.
First is 106, Your Lordship. In so far 106 is the prosecution has proven the case beyond reasonable doubt because there are three incriminating evidence because of the false statement that adds to the link.
Just give us one thing, two things. What is the date of when they took Biplab Das?
Lordship, it was
18th of February.
18/9.
18th went missing. FIR? 19th of
February.
which year are we looking at? 11?
2006, Lordship.
2006. And body recovered?
Body recovered, Lordship, on 24th.
Body recovered 24th?
Sorry? 21st. 21st February 2006.
21st February. Postmortem is 22nd? 22nd. Postmortem says within 48 hours.
Lordship, 2 days or within 48 hours.
Yes.
So, Lordship, so far 106 is concerned, there are three incriminating circumstances and he's failed to discharge.
And according to the evidence, they were in the graveyard on 18th or 19th?
18th evening.
18th evening. Yes, carry on.
Now, Lordship, I'll just forward first for 106, second I'll forward section 8 of the Evidence Act, conduct.
Let's just say.
Lordship, kindly appreciate that what is the conduct of Bonnie or Bernard after the the Biplab Das died in his lap. We had jumped the gun to come back to only on the issue of 106 to see whether it was correct or wrong. But Lordship, kindly see the conduct of Bonnie after discovery. What would be a normal code of conduct of a person, if somebody dies in his lap, he would have immediately, Burnett knew Biplab very well. He would have immediately contacted his friends, Navika, or there are so many other witnesses. This would be additional incriminating circumstances, Your Lordship, so far, which we'll find through it. First would be, he would have informed, Burnett and Bonnie would have informed through a common friends. There were a lot of other people who knew them. He did not do that, Your Lordship. Second would be, they would have not buried the body. Third, Your Lordship, they would have behaved like a normal people, informed the locality, somebody in the locality.
That is over. That is number one. Did not inform. Second, buried the body.
Buried the body. These are not normal conduct. Third, Your Lordship, did they go to inform to the police about the death?
All of this is covered by one.
Lordship, sorry.
Whether police or anybody else is all covered.
They basically the conduct was that they suppressed they chose to bury rather than informing. So that's a very, very serious kind of a conduct. It adversely proves that they are somewhere involved. This is additional incriminating circumstances which gets credence
At
from
least
such
it shows a kind of guilty mind.
absolutely.
The extent of the guilt, let us not jump the gun,
Lordship.
but it shows some kind of guilty
Some
mind.
because this is not a normal behavior, Lordship. Now, Lordship, the situation is now when were they how were they apprehended? The date of arrest is very important. They did not do the normal thing that they were supposed to do. Now, how were they arrested, Your Lordship? First of all, Your Lordship, Bonnie Fawa, an arrest warrant was issued and he was arrested on 23rd to 2006 at 9:30 am.
Bonnie, what is his name?
Bonnie Fawa. Lordship, that is volume 1, page 50. Arrest warrant is at page 50.
No, we didn't have to see the arrest warrant.
No.
Just tell us the date.
The date is Bonnie is arrested on 23rd to 2006. Volume 1, page 50. Volume 1, page 50.
Yes.
Bernard Lingdo was arrested on 22 2006.
On 20th.
20th, Your Lordship.
Yes.
Now, Your Lordship, they did not even surrender the conduct, they were arrested. Not only they did not inform, but they were escaping, they were evading from the
This,
script.
in the Indian context, we will take
Okay.
will hardly any importance to this.
Now, Lordship,
Because our police are not the friendliest. No one, even if I were in their shoes and had no other intention, I would also not want to do that. So that we can't take against them.
Lordship. Now the issue comes, Your Lordship. Can we get some lead regarding the murder weapon and the body? First is, Your Lordship, inquest report. Inquest report was of 21st to 2006 at 3 p.m.
Inquest report, where is it?
Page 413, Your Lordship.
413.
Date is 21 to 2006.
413 is in which volume?
Volume 1, volume 2.
Date is 20.
20th February.
Inquest is 20th.
Lordship.
Can't be.
To 21st, Lordship.
Body found on 21st. Inquest can't be before that.
21st. So, Your Lordship,
Yeah.
body was found.
Volume 2.
Volume 2.
Yes.
Lordship, body was found on being led by Bernard on 20.
No, you have to show us the evidence. Don't give us the conclusion.
No, Lordship, I'll go to the evidence. But
No,
this,
you went to the inquest report, so we are at the inquest report.
Lordship, so far, Lordship, allow me to read page 413. Lordship, S.B. Thakur is the IO was in
He
charge.
received the dead body. This is dead body receipt.
Lordship.
Where is the inquest?
413, Lordship, 413. 413. Type copies are 413, Lordship.
Both have power.
Lordship.
Oh. But uncle and nephew need not have the same name here.
Plan. Yes, could be.
Yes.
And Lordship, this statement by PW33, who is the IO, Lordship, he has also noted this fact at page 321, volume 1.
So we are first doing at the behest of body of Bernard.
Bernard, Your Lordship,
Discovery
of the dead body.
per Bernard. Page
Page 320, Your Lordship, volume 1,
PW
33.
33.
33 is the IO, Your Lordship. The relevant page, Your Lordship, would be page 321.
Yes.
First, second, Your Lordship, third paragraph from the middle in page 321 on leading of the accused.
That's merely an allegation. Where is the compliance?
Compliance of section 27.
That, yes.
Lordship, I'll come to that part.
No. That, otherwise we won't even take notice of this.
But Lordship, that is
This is an allegation. This at this stage is an allegation.
that is an allegation, Lordship.
Now, where is the evidence that Bernard led?
Lordship, that was not recorded on 27. I mean, I have to admit, Your Lordship, the police.
So therefore, but we forget that Bernard led. If that goes, everything goes.
Lordship, but that can be protected under section 8 of the evidence.
No. It will. That will never. We will not even extend that. If neither of the accused has taken you to the dead body, everything else fails.
27, the preliminary.
Everything else fails, Mr. Khan. After
Then
that,
that is not recorded.
if
But
neither accused has taken you there, everything fails.
But Your Lordship, I'll just satisfy Your Lordship. Allow me to just present this fact.
Yes.
There is a
There's an
judgment.
allegation.
Lordship, there is a judgment that suppose under Section 8 it can be made admissible. Your Lordship, so far body is concerned, Your Lordship, this particular statement of the IO was neither contradicted nor denied in the cross. So, Lordship, so far body is concerned, the IO has made a statement, inquest report says, and there is no denial in the cross, neither it was been shaken. The only requirement, Your Lordship, would be whether it is admissible under Section 27. Lordship, my respectful submission, Your Lordship, this is, even if there is no compliance with Section 27, law is very clear on that, Your Lordship, it will be admissible under Section 8, with the conduct part.
Can't attribute it to them.
But Lordship, the conduct part, Your Lordship,
Let us see how you build up.
I'll build up, Your Lordship. The law point will build up, Your Lordship. Allow me to just present the fact. And so, Lordship, we come to the rope part, rope. Rope is, Your Lordship, at page 443.
This is discovery.
First is discovery, body is over, Your Lordship.
Discovery. Second is murder weapon.
Your Lordship.
Yes.
443, exhibit 16, Your Lordship.
Page?
443.
No, sir. With respect, you should begin with the postmortem report showing,
Oh, sorry, Your Lordship.
and then you come. Then it becomes the murder weapon.
We'll come to postmortem. Postmortem is at page 60, Your Lordship. Volume 1. Page 63 is the finding. The type copy, Your Lordship, starts at 63.
At page
63 of volume 1.
63.
There's a type copy, Your Lordship.
Yes.
Finding is at page 65.
Yes.
And Your Lordship, postmortem doctor is at page 100. She is PW2.
Why hard, blunt, long rope? High or broken on both sides. Yes. Then the rope.
Lordship, rope is 443.
443. This is PW? Or is this the serial list?
Serial is, Lordship.
Coconut rope length around 9.5 feet. Signature witness Deepak Das, who's Deepak Das?
Deepak Das is one of the police witnesses, Your Lordship. PW 18.
Deepak Das is PW 18.
And J.S. Gill is PW 25, Your Lordship. One of the witness.
No independent person.
On this, it doesn't look like.
In the event, ordinarily, again, when you are talking of conduct, state of mind, it applies both sides.
Lordship is correct.
It
Absolutely correct.
applies to you also,
It applies to me also, yes.
because you're the IO. In custody, Bernard tells you, I'll lead you to the dead body. As a prudent person, you would call two local witnesses or two independent persons who would later come and give evidence. Yes, they were led. Yes, this is found. Nothing of that kind.
Lordship, I admit.
Everything is just police managed.
I admit, Your Lordship, that is slightly a defective investigation by the police so far. The initial recording is concerned, Your Lordship. We're not denying it, Your Lordship. But Your Lordship, PW 25 means J.S. Gill, one of the witnesses, Your Lordship, that is page 283, PW 25.
PW 25 is page
283.
283. You will also show if there is any contrary evidence,
Lordship, yes.
because then otherwise,
Lordship, I'll... 283, Your Lordship.
yes,
Lordship, 283. He says, Your Lordship, I went to the PO along with the accused, Boni Fawa. So
straight away you have to disbelieve him. I went to PO along with accused person, body power. Wrong. Contradicts IO, who says Bernard. Over here it becomes Bonnie.
There
Lordship,
body for the
Boni for the rope, Lordship.
burner for the body. On two separate.
Lordship, Boni.
So they were not on the same occasion. This was not
No, Lordship.
during body.
No. Lordship, rope is 24 and body is 21.
Okay.
21 to, Lordship, we just clarify the facts, it will be easy for the court, Lordship. 21 to 2006 is body,
Yes.
and body is being led by Bernard. (24 to 2006 is the rope, and rope on being led by Bonnie.
I went to PO Bonifawa and IO. On arrival, I recovered one coconut rope of length with seized, prepared, put my signatures.
And in the cross lordship, he is denied. It is not a fact that was not recovered on being led by accused Bonnie.
This is too dangerous to go by.
And lordship, come back to another second witness, lordship, page 295, PW 26. P26, page 295, lordship. The third paragraph.
Yes.
He says, Your Lordship, first thing, Your Lordship, the date is important. Finally, on the same date at 24/2/2006 at about 1:35 p.m., one coconut rope length so and so, around 9 inch has been recovered from anthrograph grade. The said rope was identified by accused Bonifawa, and the said rope was seized and sealed and packed in its place of occurrence. And Your Lordship will come to page two next page, Your Lordship. From the middle, Your Lordship, the fourth para, it is a fact that as this is the single jute rope produced before the court, I am able to tell that this is the one that was seized from the PO.
Nothing, very weak.
No, nothing, Your Lordship. No, Lordship, only discovery of rope and the identity. Lordship, can I crave the leave of the court only on this issue if I satisfy the law point? It'll be easy for me otherwise if I have to rely on the judgment. Just what?
Yes.
We've given the list, but we'll just provide it. Right? No. 2005. Yeah. Also, para 9, page 721.
Yes.
Lordship, allow me to read. By virtue of Section 8 of the Evidence Act, the conduct of accused person is relevant. If such conduct influences or influenced by any fact in the issue or relevant fact, the evidence of circumstances simpliciter. That the accused pointed out to the police officer the place where the dead body of the kidnapped boy was found, and on being pointed out the body was exhumed, would be admissible as a conduct under Section 8. This is important, Lordship. Irrespective of the fact whether the statement made by accused contemporaneously with or antecedent to such conduct falls within the purview of Section 27 or not, as held by this court in so and so. Even if we hold that the disclosure statement made by accused appellant is not admissible, this is relevant, Lordship, not admissible under Section 27 of the Evidence Act, still it is relevant under Section 8. The evidence of investigating officer and PW so and so, the spot Mazar witness that the accused had taken them to this spot and pointed out the place where the dead body was buried, is an admissible piece of evidence under Section 8 as the conduct of accused. PW1-2 at the place where the ransom demanded was to be fulfilled, and the action of fleeing on the spot party is a relevant fact and circumstances and are admissible under Section 8 of the Evidence Act. So, Lordship, I had made a submission, even for the sake of argument, if 27 was not complied. Under Section 8, it is a relevant fact, Your Lordship. There is a distinction between admissible fact Section 2745 is an admissible fact. But on being led, Your Lordship, the IO and PW 2526.
Look at the PW over here. PW 1 and 2 are not police. No, Mr. Khan.
Lordship is correct. We're not denying it, Your Lordship, but
You've killed your case by citing this judgment.
no, Lordship, I'm only on the principle of law.
The principle of law, what you cite is you've killed your case on the principle of law. You must be very careful in what case you cite.
I'm onto the admissibility part.
There's no, whatever comes from the police, we don't take cognizance of it. But that is the base. Let us see to what extent it is corroborated.
Absolutely correct. I'm only onto
There is no corroboration at all.
Lordship, I'm onto that, whether this fact is relevant. For the
In fact, we can't look into because there's no corroboration.
But then, Lordship, IU's statement has been corroborated by
It has to be corroborated.
by 25 and 26.
Has to be corroborated.
And that is not been
Either
not been shaken.
the statement written before or taking witnesses, somehow there must be some material other than what emanates from the police, which should give us the sense that this may have been the position. Otherwise, you're the police, you're the investigating agency. You frame everything and you put it over there without any independent corroboration.
Lordship
It's
is correct.
dangerous to take that into account.
Lordship is correct, but that was neither shaken nor disproved in the cross. They had an opportunity.
They don't have to do that.
Lordship is correct. Lordship is correct.
They don't have to do that. Why should they go and put their head on the block?
Lordship, so far this present position of law is concerned, there is a distinction between
Worse than we had thought.
relevant fact and admissible fact.
And you're completely ruining the case by going up the wrong line. There may have been some chance, but we had ignored all this. The moment you emphasize all this, it's finished.
Lordship is only for the purpose of relevant and to add another circumstance, Lordship. Otherwise, Lordship, on 106, I would have concluded my argument, Lordship. But this is only for the purpose. Lordship can disagree with my submission that because it's a police witness, it cannot be made.
It also shows your frame of mind. You have gone into presenting material which is not corroborated to show that these guys are guilty, which will count against you.
Lordship, that defective part of the investigation, Lordship, is aware. We have serious constraints, Lordship. And the more we go into that part, the procedure part, the more. But I'm not going into that part of it, Lordship. Whatever available, admissible and relevant material, I'm trying to connect the dot. If it fails the test of section 27, Lordship, at least under 8 it will be irrelevant. And relevant, Lordship, only for the purpose.
It would be relevant once we are convinced that had happened.
Now,
To
Lordship,
link it to them, we have to be aware that this is what happened. Today we have uncorroborated allegation only from police, and who are also self-contradictory.
Lordship, on this fact, there is no contradiction, neither just with this.
PW 33 is contradiction. PW 33 is contradiction. We'll demolish 18 and 25.
Lordship, PW 18.
Sorry, 18.
Lordship, to answer that query, Lordship, I'll rely on judgment. Precisely
Judgments don't make up cases. First, you have to get your facts. Judgments don't make up cases.
On the issue of fact, what happens when the IO statement is, when the Caesar witness turns hostile? Can the IO statement still sustain?
Is that the case over here?
P18, Lordship, P18, one of the Caesar witness.
He was hostile, you did not declare him hostile.
He make a wrong statement.
So therefore,
Lordship is. Can you overlook?
No. The hostile and wrong statement are different.
Lordship is correct. We did not declare him hostile.
Then,
Lordship.
but
But
can an independent witness?
can we overlook him completely? Can the court overlook that witness?
No, the court will not overlook. He is, at the end of the day, he is a police personnel.
Lordship, allow me to address the legal issue only in this
The
point.
legal issue is different when it's a hostile witness and when it's your own witness.
Lordship,
We don't declare hostile who says something else.
Lordship, of my son, there was a mistake of the public prosecutor. Lordship, there was I admit, Lordship, there was a glaring error. That should not have happened. But then, Lordship, kindly allow me to place the judgment, at least to satisfy the court on
If we
that.
had confined it to that part, there could have been something. The more we are opening up the Pandora's box, you're drowning yourself.
Can I just... Para 9, Your Lordship.
Just a second. 1978-4.
Lordship, now to read.
Yes. Just a straight line. If the evidence of the IO who recovered it is convincing, the evidence as to recovery need not be rejected on the grounds that do not support the prosecution version.
Lordship will kindly appreciate
It's not convincing.
PW 13.
It's not convincing.
Lordship, IO is PW 33. His version is corroborated by PW 25 and 26. Now, in this judgment, it was only the IO. Our case stands on a much better footing. It has been corroborated by 2 witnesses. Only PW 18 makes a wrong statement, Lordship. So basically, he does not support the prosecution.
And what happened in this appeal? Judgment reversed, acquitted.
Lordship, yes, his case of acquittal.
Never cite an acquittal judgment. These are cardinal principles.
But Lordship, only,
Just because of one straight line, don't cite an acquittal judgment.
Lordship, it was very difficult to, that gap principle of law, what happens to the IO statement? And then, Lordship.
Yes, all that we have, therefore, is Bernard's statement and Bonnie's statement and nothing else. That's not good enough.
And
Because
they fail to discharge.
that's not good enough because merely on the statement we can't. Merely on the statement we can't.
But Your Lordship, they have failed to discharge 106, burden of 106.
Yes,
And Your Lordship, just,
we'll agree with the easier job. We'll agree with the trial courts. Yes, what else is there?
relying on,
Only judgments, no facts. No evidence, nothing. You're only going on judgments. Dangerous territory.
Lordship, so far last seen is theory, concern, Your Lordship. Lordship wants to delve elaborately because the admitted position was very clear that the
Let us see at least
yes, Your Lordship.
the two statements, 164 statements.
Lordship, yes. Lordship, yes.
We are quite happy that they were there, they may have committed it. But in the absence of evidence, we can't convict them.
Yes. (23) is Bonnie, Your Lordship, for volume 1.
Bonnie 164,
Is that page 23?
page 23.
Type copy.
What were the charges? What were they charged with? Sections?
Kidnapping and murder.
Sections?
360, 367A and 302.
364A and 302.
302.
So you are only on the 302 aspect now.
Lordship, yes.
You have to get to the 364.
364 would be, Lordship, prior to what happened prior to me seeing together.
We'll come to that. It's a lesser thing if you can establish that also. If you can establish 364A, to some extent, your 302 would be done. Anyway,
Page 23.
And
Page 37, right? Bernard.
who is whose uncle? Who is uncle, who is nephew? Bonnie and Bernard?
Bonnie.
Bernard is nephew, Bonnie is uncle.
Bonnie is uncle.
Bernard nephew, Bonnie uncle, or Bonnie uncle, Bernard nephew?
My lord, I have not sought instructions to this regard, but the statement under 164, they are contradictory. In both the statements, it's written that Bonnie is the uncle, and in the other, it's written Bernard is the uncle.
Yes, exactly.
Because these statements.
What are their ages? What are their ages?
Was it that time? 160.
You'll get it from the first page. of
What
the
about
thing.
the first page? Bernard is 23.
Bernard is was 23
Was
and
23.
Bonnie was bigger.
Bigger. Bonnie also stated.
Bonnie also, my lord, appears to be 23 only.
And Bernard?
Bernard also 23.
It appears that Bonnie is the uncle because the question by the magistrate is whether Bonnie, your uncle,
My lord, if I may interrupt in between, my lord.
yes?
My lord, this statement under 164 was recorded in Khasi. So I am not very sure, but the word woman is used for relative.
Very well. Quite incoherent. Yes, anything else, Mr. Khan?
Lordship, from the 164 statement, minusing this exculpatory part, Your Lordship, there are three important relevant facts that comes out, which are admissible. First, Your Lordship, would be that last scene theory. I'm not into that, but that is clear, Your Lordship. The last scene theory, they never came to the witness box too. There was no retraction. They never came to the witness box to challenge that. They have denied in 313, rather they have made a false statement in 313. They don't pass the test of magisterial scrutiny, and they don't pass the test of truth. They have not discharged the burden, Your Lordship.
So all that we have is these two accused voluntarily making a statement that they were the only two persons one evening at the graveyard with the deceased. One of them says that he died on my lap. What the other one says, we cannot look into. But both of them talk about Bernard rubbing the soles of Viplav's feet
Lordship.
to try and revive him.
Lordship, yes.
That part of it is very key because both of them refer to that.
Lordship is correct.
It's very important because at least that's something we can use to as acceptability of the statements. Then, of course, there's confusion as to when the grave was dug.
He said, one of the person, Bonnie said he dug in the morning. It was asked by Bernard.
Bonnie said
Bonnie said, he said there in that 164, Your Lordship. He said he dug it in the morning.
he dug in the morning.
That's very important fact, Your Lordship. He has not retracted it.
Which is also said by thing, but again, it's an accusation. We will not take that into account.
Lordship.
But Bonnie says he didn't know whether it was used or not used, where he had dug it. That's not very important. There could have been a skeleton or bones.
Absolutely, Lordship.
It's not important. As long as there was a hole, they put it
Absolutely, absolutely.
And they left.
And then, Your Lordship,
Now let us see whether this, only this and nothing else is enough to nail them.
Lordship, yes.
Nothing else. There's no other material that you can show.
Lordship, in situation as this, the last seen theory is itself is
There is no last seen theory over here. There is last admission theory.
last admission, sorry, Lordship, not last.
There is no last seen theory over here.
Last admission theory, Lordship is correct.
This is the admitted position that we were last together with him.
Absolutely correct.
There is no last seen.
And it has come from them. That is more
from
important.
them.
More important.
Come from them. They are not trying to commit suicide. They are not trying to take the blame to shield somebody else. To some extent, it's not self-incriminating either.
Either.
Both of them tried to make out a story where
It turns out to be false.
they are intending to escape the net.
Absolutely correct, Lordship.
That's the nature of how they tell the story.
Lordship, we are very
Is
grateful.
this good enough?
We are very grateful, Your Lordship.
The rest of it is really irrelevant.
Lordship, we are extremely grateful, Your Lordship. The evidence part has come out very. Otherwise, there are so many things, Your Lordship. We can go on for the whole day and we will not reach anyway. That is the clinching part, Your Lordship. So far, Your Lordship, that's why, Your Lordship, I was making a parallel argument when it comes to Section 8. What would have been a normal conduct? Lordship, that aspect, Lordship, has to, I think we'll have to look at it afresh. Not only it is a false statement that he died of vomiting in his lab, postmortem corroborates and postmortem clearly says that this was wrong. And his normal conduct would have been
Now, how do we
informing.
distinguish between the offence committed by Bonnie and that by Bernard?
Lordship, he would be under if not 302, at least the kidnapping part, 364A.
Where is that? We have only seen the 302.
Lordship,
Where is the 364A?
Lordship, the
Come to the 364A.
364A, Lordship, 364A will have to start the evidence right from stage 1 from Police Bazaar till the
We'll
grave.
go to that. First you tell us the story and then you show the evidence.
The story, Lordship, is that they met in Police Bazaar. What emerges, they met in Police Bazaar, and from Police Bazaar they had some ring. And it was planned that they'll go out somewhere. All thing was planned, and then when they left Police Bazaar, they went to Polo. From there they took an auto rickshaw. From auto rickshaw, they went to the graveyard. Before reaching graveyard, they went to a PCO. From the PCO, they rang up Narvika, one of their closest friend.
They did not ring up.
Biplav Das rang up. Biplav rang up. So from stage 1, 2, 3, 4, and then when we have to see that part of Lordship, the whole intention, and then in Bernard's statement it came out that they were talking to each other, they wanted to make some money, and they had a discussion prior to it, and they didn't realize this ransom part would be taken up so seriously. That has come up in admission. So that will be the base statement for us.
They've been completely acquitted
Lordship.
of both charges.
Lordship. So that will be the baseline, Lordship. If the case of prosecution is this, we rely on some other witnesses and then build up. Lordship is absolutely correct. Then maybe we have a very shaky ground. But what happens, Lordship, if we start the case on the admission made by them, what we need is to complete the chain so far kidnapping is concerned. Right from Police Bazaar till they were together, last seen together. The intention was very clear.
But there is no element of kidnapping in their admission.
No, Lordship, but there is a discussion that they had pre-planned it for some ransom, and he didn't realize Bernard.
Where is that? Where do you get ransom?
But Bernard making a statement that they had discussion on.
Take money. That does not mean ransom. That could be a loan.
Lordship is correct. Lordship is correct. Some evidence has been let, Lordship. I'm not going to that part of it. There was a phone call from father. That is again.
At the highest, Bernard gets 201 and Bonnie gets 302.
Leave it to your Lordship.
Bernard, no more than 201.
Absolutely, leave it to your Lordship. That's why, Lordship, we're very grateful. At least the principle finally has come out very clearly. And Lordship, this is the final principle of criminal law again, Lordship. There are incriminating circumstances. Maybe I'm not able to put it. Those are very crucial, Your Lordship. In a case like on admission being seen together. Otherwise, there is no way out, Your Lordship. Otherwise, there is no way out. Had that gap been long, Your Lordship, then maybe the prosecution case would have collapsed. I'll admit, Your Lordship. Had that gap been long. Gap being very small and false statement. Lordship, can you have just one judgment without bothering the court, Your Lordship, only on this last in theory? Three. Missing link, Your Lordship, only an issue of missing link. What happens if the burden is not discharged and then what happens to that incriminating circumstances?
Some AC or something has been switched off. Why? You were feeling cold. Then? Who switches off? On whose instructions? With whose permission?
Yeah, please, Your Lordship, para 27, page 480. 27. Start from page 26, Your Lordship. From para 26, page 479.
Paragraph?
26. What has just now fallen from Your Lordship, that is exactly what was discussed here. Possibilities. Relevant is 27, but the background is at 26.
We are aware of this. This is not the case over here. I wish
Para
it was
27.
like this.
Para 27. Para 27, Your Lordship, from the bottom, the fourth line. So, Lordship, my respectful submission is that false statement in case like this has got a serious implication insofar additional incriminating circumstances. Had it been a true statement, Lordship, if we assume the situation, had it been a true statement, he would have admitted making a statement to magistrate. He would have admitted he died on his lap. Then what would have been the consequences? The burden would have been very heavily on the prosecution. Now, in these two situations, which was very vital for him, he made both false statements. Admittedly, Your Lordship. And if he has made the false statement, Your Lordship, that's an additional, very vital missing link. And that also gets, the 313 not only gives that additional link to the prosecution, that also gives leverage to the prosecution.
Let us see 313.
Three 339.
339.
For Bonnie Linda is 339.
Bonnie?
For Bonnie Linda. First for Bonnie Linda, Your Lordship. Starts from 339, volume 1.
Where is the English version?
English version, Your Lordship, starts at 3. $359.
359.
59. Relevant question would be, Lordship, 15 and 20. 20 is very specific. Page 367.
Question 15 and
15 and 20, Your Lordship. 20 is directly.
20.
First, Your Lordship, we come to 15. This is what the defense counsel raised there. Page 365.
No, he said answer to 20 is I did not state.
Question 20, Your Lordship, that you had stated in the graveyard you had asked victim Biplab Das to lie on a lap. What do you have to say? I did not state anything as such.
Yeah.
And 15, Your Lordship, they are denying we having given 15.
That's all right. There are 15 is only thing. All right. Where is the other Bernard?
But that is 386, Your Lordship.
Where is the English version?
Lordship, the same, Lordship, 386, English, and question is asked in English, translated, answer is in Khashi and again translated.
Right, where is magistrate's evidence?
The magistrate is 313, Lordship.
313.
313, volume 1.
So she was a judicial magistrate.
Lordship.
Who is Ayub Kharpongkar?
He was discharged, Your Lordship. Charge was not framed again.
All right. Who is David Abhijit Gomes? Okay. Ranjan Chetri?
These are all
David was the friend.
friends from Police Bazaar.
And Ranjan Chetri?
These are all, Your Lordship, from the Police Bazaar, Your Lordship.
Anyway.
Lordship, even if Lordship has a look at PW 31.
Yes. Come to page 318. What is this thing about the date? She says that statement of Bonnie was recorded on 9th March. But Exhibit 20 reflects the signature of Bonnie as 8th March.
Lordship, yes.
What is the anomaly?
Slightly was in Lordship, there was a problem. We admit, Your Lordship.
Then on being shown the order sheet of the case record today, I say that there is no order dated 9/3/2006. It is not correct to say that in the statement of I've incorporated my own knowledge of the case in a later date.
Some minor technical issues, Your Lordship, regarding insertion of date.
Let us come to see and what is that minor technical issue?
9.
Page 359. Show us where is the anomaly.
Question 15, Your Lordship. It's
Sorry, that will be page 23.
23. Sorry. 23. The 11th page would be page 24. Your Lordship. The date mentioned is 9/3.
Page?
Page 24.
Yes.
Right side, Your Lordship. RONAC. Sand is at 9/3.
Where is the original?
Original will be at page 18, Your Lordship. On the right side, it's 9/3.
Just a second. Come to page 12 where it begins. Where is the date on this document?
Page, first page is not there, Your Lordship.
At page 14,
Page 14, it is signature of the accused is
Bonifaro's signature is of 8th of March.
8/3/2000.
Signature of the magistrate does not carry a date. Page 15. Again, no date.
No date. This is.
Anything else?
Lordship, on the conduct, I just like to take it up to PW 17, to page
PW
235.
17.
Lordship, 235.
Page
235, Lordship.
and then
235, volume 1.
235.
235. Lordship, can start from the third paragraph, the relevant,
Just
on the issue of conduct of Burnett. This is the starting point of.
police.
No, not police, Roger. He is Roger K. Sangma. He is a student of St. Anthony's College.
Oh.
This witness is very important to show the conduct. Para 3, Lordship. Lordship, we can skip 226 except from the last bottom, the fifth line. We get the
No,
link.
no, when we read the full.
Oh, Lordship, apologize.
He was not cross-examined by body,
He was lodged.
just cross-examined by Bharat.
Burnett, sorry.
Cross by Boni is
Is there?
there. Cross by Boni is at page 238.
Where, madam?
Lordship, from the bottom, the last
yes,
four
yes,
paragraphs
yes.
are by Boni.
Yes. Was the PCO person examined?
Yes, Lordship, yes. Yes. PCO person is at PW 22, Your Lordship, page 278.
PW?
22. Page 278.
Page?
278, volume 1. But you might just add actually, let me just take your lordship to page 399 of volume 2.
What is that?
Actually, this is the same, we have exhibited this PCO receipt with a phone number. PW17 is regarding the last call made on 18/6 from PCO Maulai to Nirvika. So we have exhibited one.
Where do we find that?
Lordship, on Lordship, can you see this on the top here?
Yes.
On the top, there's a phone number here.
98630.
03577. This is the same number. The last call was made by Biplab Das. PW17 has mentioned it. Lordship.
How do you know that that is Nirvika's number?
That was stated by PW17, Your Lordship. And we got the PCO detail. This is the PCO detail.
Yes, but how do you know that that is Nirvika's number?
That, Your Lordship, only evidence we get is from the statement made by PW17. He makes a...
Yes, he does say that number.
Lordship, yes.
Nirvika was not examined?
She was examined.
And no question put to her, what is her mobile number?
She's PW6, page 145.
That would have been the better way to do it, direct and forthright.
No, the number is not there.
Any 161?
No, Lordship. Sorry, Lordship, 140, page 148 in the cross. Page 140. No, there's a different number.
First number.
It's in the-
366.
Lordship, we find at page 401, number mentioned at page 148, 986 306 7363. This number, Lordship, we find in exhibit 11 at page 401 of volume 2. Bottom, Lordship.
why do you show us the wrong?
Apology, Your Lordship.
If I hadn't asked you the question about this, this would have gone. And that would have been a complete error.
Absolutely, Your Lordship. Yes.
As it is, we are taking it into contradiction because the time did not tally. If you look at number 1, it says 1713. 1713 completely is against the evidence. 810, 818 is closer to the time. Nine, 8, 6, 3, 0,
6.
6, 7, 3, 6, 3. 6, 3. Page 148. She is PW?
6.
6. Nirvika Singhania.
Nirvika Singhania.
Anything else?
Lordship, we'll just take to page 24 of the
24.
Again, 24, Lordship. Another. Volume 1, page 24, the statement of Bonnie.
24, yes.
What more do you have to say? There are two questions. While burying the dead body of Biplab, Bernard told me we better take out the purse and mobile set of Biplab, so that the dead body will later not be identified. So we took them as a discuss. The next question, what have you kept? Where have you kept the mobile? Bernard gave me the mobile, and I went to sell the mobile to one person, telling him that I barely need money.
Yes.
So, Lordship, this fact is come. So, for the mobile taking from deceased is an admitted fact, and this has been corroborated, Lordship, by PW 8, page 158.
Page 148.
158, Your Lordship.
158.
PW 8.
How do you connect it to
Lordship,
the deceased?
before that, Your Lordship, the connection starts from page 24, where Bonnie says he picked up the mobile and is given to a close friend. Now, the first seizure was done by PW 9.
No. Has it been established that Exhibit 6 was the mobile of the deceased?
Lordship, that part, yes, I admit, Your Lordship.
Then?
I'm just only on the relevant part that the mobile which was taken by Bonnie, and the additional fact, exact whether that was a mobile, that has not been established. Let me admit, Your Lordship. But the taking of the mobile, I'm only into that, taking of the mobile, giving it to PW9. PW9 recovered the mobile at the behest of Bonnie, and then PW8.
Has it been disproved that it is a mobile of Biplab?
No, that has not been disproved.
It's not been
No,
disproved.
not been disproved.
It's not been proved, but it's not even been disproved.
Not, we rely only on the statement of 24. So if he had admitted that he has taken the mobile, so what has he done with the mobile? Conclusively, we have not proved that it was his mobile, but PW9, 8 and 21, Your Lordship. These are three witnesses who have been handling this mobile, and it emanated from page 24, the statement of Bonnie. So there is additional incriminating circumstances. And it's not the other way around, Your Lordship. We seized and we had to prove. it was an admitted fact by them. So which is a relevant fact under section 8. Lordship, can you see page PW 9 163?
That's right.
How it was seized.
And page 150,
163. PW 9 163.
162,
163, Your Lordship.
163,
PW 9.
PW9, police person.
No, she is.
That's all?
No, she just 1, 2. PW 21, Your Lordship, page 273.
PW,
21,
page
273.
who is he?
And Lordship, he is again, Sardar, he is a police personnel.
He is head constable.
Lordship. And Your Lordship, last submission there. If I take Your Lordship to page PW 31, page 309. Lordship. Lordship, the prosecution is relying on this witness. Only for a limited purpose that is an independent witness.
Who?
He's a PCO cameraman, PCN channel. PW 31, 309.
PW 31, page
309. Lordship, there is no reason why he would say anything.
Let us see what he says before we come. Cameraman.
Cameraman, Lordship.
Cameraman meaning photographer or?
No, PCN news channel, Lordship.
Oh, cameraman in news channel.
News channel. And he says his function as a cameraman is covering news in around Shillong and also outside Shillong as required. So, Your Lordship, Lordship, even if you discard,
Just Where is this video?
Lordship, I have to admit, the Lordship, the video part was not exhibited in the court. In fact, I was trying to contact the public prosecutor who conducted the case. So they could not get hold of the CD even at that time. Maybe it was spoiled or something, but nothing has come on evidence. So Lordship, I'm not going to that part. That would have been absolutely clinching. But Lordship, can you appreciate? So, Lordship, even if you discard PW 33, 25, 26, being police, he is a cameraman, he's an independent person, and he makes a statement on oath that he saw Bernard on being shown the spot by the said Bernard. So, if we exclude 27 for some reason, if it does not meet, but this comes very clearly under the meaning of Section 8, that the body was shown by Bernard. And there's an independent witness who saw it. And this has not been shaken in the cross. So, Your Lordship, the gap between last scene and...
That's all?
That's all. So, Lordship, my last submission would be, Lordship, this is a fit case. Only for two reasons for this court to interfere. First, Your Lordship, the only ground that the trial court has acquitted is using section last scene theory has gone on a totally different premise. None of the evidence has been appreciated. So it's a case of totally perverse finding of acquittal.
This aspect, you don't have to concentrate on the entire thing.
No, only vital part.
Only on whatever you have relied on,
Lordship.
how that has been dealt with by the trial court.
Lordship, none of them has been dealt with.
Those aspects have been dealt with by the trial court?
None of the aspects. The trial court has misdirected itself into a
Yes, madam. When should we keep the matter?
If Your Lordship would suggest...
No, we had known that we'd not be able to do it today.
Yes, my Lord.
Finish it today. So, when?
Lord, as Your Lordship, if Your Lordship could suggest maybe 2-3 dates, according to that, I'll also keep. Because, my Lord, I'm a legal aid counsel in this matter. So, and I'm traveling from Guwahati.
Lordship won't be there tomorrow.
No.
I'm aware of it.
Lordship is not there tomorrow.
Next week, Lordship.
It is next week.
Monday is what date?
Lordship, we have that custodial matter Monday.
Huh?
Custodial debt matter.
That's 2 o'clock.
No, morning.
Morning.
No.
It will not take much time.
There will already be two division benches on Monday, my Lord.
That's all right.
And
Monday,
Lord,
2 p.m. Lordship, things are fresh because there are a lot of, in case I may have to reply. In
Very well.
also, my Lord,
29th, 2 p.m.
Lordship.
29th and 30th, 2 p.m.
my Lord.
So we will give you only 10 minutes to show how, if at all, it has been dealt with. Otherwise, we'll record your statement that it's not been dealt with by the trial judge.
Lordship.
And then they'll have to show if it's been adequately dealt with, they will show.
Yes, absolutely.
But we won't give you any more than 5 minutes on the next day.
Lordship.
And you'll concentrate only on those areas. The other aspects, if they detract from these, because we don't want the long story, this happened, that happened, where they've gone all wrong. We want only on these points, if there's any evidence to detract from these.
Lord, whatever my learned senior has placed before this honorable court today, I will be making my submissions relating to that only.
Yes, yes.
Because
and if you can discredit that, you're through.
Yes, my Lord.
Today is what? Today is the
23rd, my lord.
23rd. put this right on top and then. Brother? Oh, sorry, I just looked up for your space. No, this is your space. That is.
Lordship, highly grateful for the patience hearing. With me quite some time, we got a chance to bring in the principles of law at least.
We are going to, if we are going to reverse
Lordship is correct.
an acquittal, then we have to do it very seriously. We can't do it on.
Lordship, just recollect, last week there was a major judgment from Supreme Court setting aside acquittal of RGT members. So it was a long, very long judgment on appreciation of facts and purpose finding.
Yeah, that's why we want to
Just
concentrate
last
only
week,
on facts.
absolutely.
Want to concentrate only on facts. So that will be Tuesday,
My lord, Tuesday, Wednesday.
Wednesday. Select.